tardes a todos, bienvenidos y a todas. Bueno, pues el día ha llegado, parecía que no iba a llegar nunca, pero habéis llegado hasta hoy, habéis cumplido todas las etapas para completar este programa Masterclass. Y bueno, hoy tenemos para clausurar este año, este curso académico, a una persona que es muy importante para este programa, porque sin su apoyo y sin su constante cuidado porque este curso pueda salir adelante no sería posible. Me refiero a Manisekaran Amasi. Es graduado de la Universidad de Malasia y ya ha sido representante de su país ante la OMPI. Ha sido también director de la Dirección de Derechos de Autor de Malasia. También asesor en derechos de autor para el gobierno malayo y también consultor en varios proyectos de ley de la legislación de su país en materia de propiedad intelectual. Desde 2007 se incorporó a la OMPI. Primero como representante en el Buró de Asia y Pacífico de su país y luego en el cargo que ocupa hoy, que es oficial superior de derechos de autor de la División de Infraestructuras de Derechos de Autor de OMPI. Es una división relativamente nueva que se creó hace 2 años o 3 y que se dedica, entre otras cosas, a mantener una relación con lo que son las organizaciones que se encargan de gestionar los derechos de autor y que, digamos que, bueno, pues hacen que el derecho de autor esté vivo y que se materialice en licencias y finalmente en un mercado, ¿no? que hoy es tan importante como es el de las industrias culturales. Así que quiero dar las gracias a Mani, como le llamamos los amigos, por estar un año más aquí con nosotros para clausurar este curso. Él nos va a dar una conferencia en la que se va a centrar en lo que son las principales directrices y pautas para una gestión de derechos eficaz y en lo que es el trabajo de su división en estas materias. Mani, do you have translation? No.
Yes, okay. I think we have translations going on there.
Así que, bueno, pues sin más preámbulos, porque tenemos una tarde muy cargada de acontecimientos, pues le doy la palabra a Mani. Mani, thank you very much. Welcome for being here today. Thank you for being here today. Welcome to Madrid, and please go ahead.
Ladies and gentlemen, I'm indeed happy and honored to be here for the second time. When I came the first time, I was here to do the closing ceremony and to present the certificates to the students. But my dear friend Adriano told me that this time I must come back as a lecturer. So I'm very happy here to address on a topic which is the threshold and criteria for an efficient collective management organization, issues, challenges, and opportunities. Now, as you know, this is too open-ended, covering a very vast and wide range of subjects and subtopics. Looks like this is a borderless kind of topic. Now, that being the case, I had spoken to Adriana just before starting off this lecture that I should be in a position to cover the most salient aspects of collective management. Now, to put it into a very simple way, there are 2 kinds of management of rights, individual management. If it is individual management, the best example we can say is between an author and a publisher. An author writes a book and then he enters into contract with a publisher. Then he monitors and he controls and then is able to assess all the activities that the publisher is able to do. It is one-to-one. So it's very much possible for him to monitor from where he is. But that is for one-to-one. Then what is collective management? Let us say you are a right holder in music and then your song is played in the air. When it's played in the air, at any material time when it is aired, it is being listened to in several places, not only in this country but also abroad. Now you are a composer of the music, otherwise a lyricist. You are sitting at home, and how are you going to monitor all these songs that are heard or played in many parts of the world, including your own country? Now this is where the collective management organizations come in to monitor, and then they collect the royalties, and then they distribute, to put into simple term. Through the agents, they're able to collect and distribute. It is very simply said, but then it's very complex situation. The role of the collective management organization is to bridge the gap between the rights holders and the users. So this is the best form that we have had. Allow me to quote what my Director General, Francis Gary, mentioned at the Conference of the Collective Management of Copyright and Related Rights in Europe, that is in Brussels, on November 24 and 25, 2008. I'll quote. He says, "As you all know extremely well, collective management, depending on the situation and the circumstances, is one of the most tried and tested tools for assisting in the effective implementation of copyright and related rights or neighboring rights. Collective management is the best option that we know for returning value to creators, and WIPO has an important role in supporting this tool, especially with respect to the developing countries. Collective management also plays a very important role in developing the global infrastructure for the creative industries and for creators around the world." I think this is about the best statement that we could have on the importance of collective management organizations. But let me now go to another important element of the collective management organization, and that is the structure itself, which means for the collective management organization to exist in a legal environment, there has to be a legislation. I know of a country, as I go through the lecture, I'll be quoting examples, I'll be naming a few instances, but not the countries. I know in a country where, when I last visited, there were 29 collective management organizations. When I visited again, there were 32 collective management organizations for the same right. Now that was because of the absence of the law. So every day you get up, you have an additional CMO in existence. Now this is a clear case of CMOs coming into existence in the absence of clearly defined legislation. The pressure is on the users. In the absence of legally constituted collective management organization, the users can always refuse to pay royalty. Now that is the case. And next to legislation, you must have enforcement as a pillar of copyright. Why enforcement? Because in the event there is infringement, do you have recourse to court proceedings? That will come as part of the legal structure itself. So that is also important. And finally, of course, exercise and management. As I mentioned, it comes in two forms, exercise and management. First is individual management between the author and the publisher, which was the example I gave. The other one is collective management of the rights through collective management organizations. Now, again, I want to say there is another challenge that has to be very well met up with, and that is the prerequisites for setting up collective management organizations, or collective management organizations, which are also called CMOs. Now, there must be a vibrant copyright industry in any country for the collective management organizations to be also vibrant, effective, and functional. I have known of cases where there were very small countries, or I would say island countries in some Pacific Ocean, which actually drops or dots in the ocean, very small population of about 600,000 or 800,000 people. They had wanted to set up collective management organization. When a feasibility study was conducted, it was seen that 80% of them were involved in agrarian industry, agriculture, leaving behind 20%. Of the 20%, only a small fraction of them were involved in copyright activities. So it was very clear that in this situation, it is not possible for collective management organization to be effectively working. Now, I had also mentioned that the legal environment is very important. But again, it will be very important for the collective management organizations to be lined up with the international copyright-based treaties through their governments. which means the national governments would have to be members of the Bern Rome Conventions and the Internet treaties, and of late the Beijing Treaty for the protection of audiovisual performance. This is important because it is only through this legal environment with international norms that there will be a possibility for the collective management organizations to function with their connections throughout the world by way of harmonizing the international treaties in their national legislations. And when a collective management organization is set up, it is always to be pointed out that there should be only one society for one category of rights. If we have a plurality of copyright societies for the same rights, then we are heading for danger. I've known of a country where a collecting society was formed for the performers, and 2 years later, another collective management organization was formed for the performers, which means for the performers, there were two collective management organizations. The result was confusion in the market, and there was paralysis in the minds of the people, and all the users or the user organizations made open press statement to say that you keep your house in order and we will pay the royalty, which means you're confusing us. You amalgamate, come back, go back, and amalgamate into one society, then we will pay. Otherwise, for the same category of rights, two of you are knocking at my door. Now, this is a legitimate issue that they are pointing out. So if we have two societies, then it'll be a problem. So this is another a problem that has to be also faced if this is brought up. Again, in setting up a CMO, there had been some initial problems. First, there must be some initial funding, you know very well. I'm talking about the formation of a CMO. I'm talking about the prerequisite. Now, the funding can come through various ways. One is members themselves. Before forming a collective management organization, they normally evolve as an association, then into collective management organization. They must have, the members will be able to contribute some fees, some subscriptions towards the funding. Otherwise, bank loans may also be of some assistance. There are governments which also do provide launching grants. And of course, the international NGOs may also come in to provide some initial funding. Now, these are the ways in which the prerequisites are very well spelled out. Now, I also have to say that after the setting up of the collective management organization, there is a very cardinal point to be addressed. And this is very important because some CMOs have been misdirected out of ignorance. They were sincere, but out of ignorance, because the person who is leading the collective management organization, say the general manager, otherwise the CEO, has to be well trained, otherwise well competent or well grounded, I would say, in some of the basic elements of collective management organization. For example, he must have some basic legal knowledge. I've known of CMOs led by non-lawyers, but they had sound legal knowledge. This is very important. And again, they must have administrative capabilities to run an organization, and well-founded knowledge of tariffs, the price for the royalty, basic principles governing the collection of royalties, and they must also have sound knowledge on documentation, distribution, accounting and payments, data processing, and of course, finally, social welfare. More than that, if they are leading a collective management organization, it is best they are able to do very good lobbying among the members of the public and also among those in authority, and it will be good to have very good political context as well. This will be very important because the leader of the collective management organization is very important in winning the hearts and minds of those within the collective management organization and also the users. So this is important. Now, there are issues to be also addressed. What is the role of the government? Where does the government come in? And where does it place itself in collective management? normally, more often than not, otherwise in all cases I would say, it is the government institutions that play an important role in the initial setting up of collective management organization. In most cases, it is the Copyright Office. It is this Copyright Office which will be in a position to bring a lot of awareness to members of the public. And the state provides a legislative framework, while the Copyright Office is the one which is implementing the decisions that have been made by the government. There are copyright officers, otherwise government institutions, which also provide authorization before the operations. Now, for example, the German Patent Office, it involves in the overseeing of operation of the collective management organization. In that case, the members of the public in Germany are very clear about that. I would say the Kenya Copyright Board approves and supervises activities of the Kenyan collective management organizations. In Sri Lanka, which I recently visited, it is mandatory to provide audited annual accounts to the Intellectual Property Office. Now, these are very important because you see that the government is there in the picture, so that the members of the public are aware that the collective management organizations don't function with a high-handed policy outside the framework of the government. Let me also say that it is not as easy as we think. The collective management organizations are also having, in many places, tussle with the government. This is because the government has its own view, which is a very legitimate view, that is the government provides the law, therefore it is moral obligation to monitor the activities of the collective management organizations. The government in many cases also fears the exploitation by CMOs, especially in fixing high rates, otherwise the means of collection of royalties. And the government is also very concerned to make sure that the CMOs are seen as non-profit making entities and not business concerns. And what about the collective management organizations' viewpoint? They are also under pressure. They say IP is a private right, therefore let the owners decide their fate. And then the market economy, they say, favors private participation. And these are the arguments. And they also go to the extreme of saying that government should not decide rates on private rights. These are arguments. But then let me say in no uncertain terms that this is left to the domestic situation. Water finds its own level. In the same way, the functioning of the collective management organization and the relationship between the CMOs and the government is very much decided and determined by the domestic situation. So there is no one size fits for all. What would be an ideal situation then? Now, in some countries, collective management becomes integral part of the Copyright Office. So the Copyright Office itself has a branch which is a collective management organization. The ideal situation would be one where the national laws have some provisions for CMOs in their primary act. And the CMOs are to be legally constituted. And importantly, the government provides the law, and the government should show the way by paying royalty first, especially the broadcasting organizations. When the broadcasting organizations pay royalty first, then the private broadcasting organizations will follow suit. But the agency which provides the law must show the way. This is what we always advise collective management organizations to win the hearts and minds of those in government sector first. Governments are also encouraged to work very closely with CMOs, especially in conducting joint awareness programs. Because when the government and the CMO join hands and organize activities, then that is about the best thing that can happen in any country. Importantly, collection of revenue is not a straightforward case because you are dealing with money. And whenever there is an asking price, there is always a negotiation that takes place. And in many cases, they end up in disputes. So what do? The government must find a way of resolving this. If we go to the court, it takes a long time. But therefore, it's better to set up copyright tribunals. The tribunal will be able to address specific issue and settle the matters very fast. Now, having said this, what is the sum of everything? Then we come into an ideal situation again where we see a fully fledged collective management organization. What are the elements? In the first place, there must be sound statutes, memorandum of articles or associations. Sound, there must be clear vision and clear mission. The objective of the CMO must be spelled out. What are the rights managed must be also indicated. The membership's qualification and the fees they have to pay, if any. And then the governance structure has to be there. The CMO must have already identified who are the potential users from whom they are going to collect royalties. And they must have the capability of monitoring when, where, how, and what works are used. And this is also to prevent illegal activities. And they must also have the skills of negotiating with the users. And they must be also able to set and publish tariffs which are said to be reasonable. And in the event of infringement, they should be able to also enforce rights. And of course, they should be able to collect remuneration and distribute the remuneration. And importantly, such collective management organizations must have professional representation of their members' interest. They should promote creativity, because if revenues don't come in, the rights holders would not be able to have the incentive to also further their interest and bring in new works into existence. And many CMOs are also there to provide legal and social assistance for members. Now, these are not the only ones, but these are about some of them that have to be in place for a fully fledged CMO to function. And there are also some other challenges. I would say that society, if you study human behavior or social behavior, you would find that there are two people who are detested very much. This is not a general statement, but I've observed this. One is, of course, those who knock your door for income tax collection. Number two is those who come to you for royalty collection. Why? Because both are money. Money is going out of our pocket. Now, this is a problem. Now, while this is the case, the CMOs should be there to explain to members of the public, to the users especially, why they are existing. What is the purpose of their existence? And how do they provide the creativity and nurture the culture into maturity in any community? Now, this is where they have to contribute towards the growth of culture and development of creativity. CMOs have a devoted part of their funding for anti-piracy activities. While they are collecting revenue, piracy is eating at the roots of creativity. Therefore, they have to collect the revenue and give here, at the same time fight the piracy. And CMOs also provide music development funds, and that is interest-free loans for purchase of music instruments, and they also provide accident benefits. I'm not saying all. There are some CMOs which do this. Now, there is another big challenge. This is to demystify public concerns. Every day, this is in existence in some quarters in any country. And what are they? When the collective management organization collects a revenue, a portion of it goes to administrative costs. And this has to be explained why administrative costs are deducted. There is a tendency to believe that the administrative costs are too high. So it is best to keep it low. Administrative costs generally should not exceed very much. It's about, say, 20 to maximum 30%. If you keep it around 10%, then it's a feather in the cap. Where does the administrative cost go? For the rental of the building, for the payment of the salary of the staff, and also for other amenity, other electricity and water and running around and all this. So the members are always concerned about keeping the administrative costs low. And there is also tendency to make sure the users are, the money is used for proper purposes. And the members of the public may also ask, otherwise the rights holders will ask, how come you collect so much, but a portion of it or major portion of it goes overseas? Now that has to be explained because the collection of royalty is based on actual play of songs if it's in the music industry. So actual usage of the works. So if more usage is for foreign songs, then naturally more money will go accordingly. This is important. And there are also some frequently asked questions whenever I go. I had gone for seminars for 10 years when I was in Malaysia director of copyright. And wherever I go, more or less the same questions are raised. And these are again challenges. They say, why do the user have to pay royalty when he has already purchased the cassette or CD? Now these, they take the original CD, they don't see the circumference where it is written that reproduction or duplication or public performance is strictly prohibited. Now there are statements made there, but they don't read that. Now they say I've already paid money to the purchase of the CD. So why do I have to pay royalty? Now there are two situations where you don't have to pay royalty. First, you must understand purchasing of a CD is in no way a right given to you to transfer the rights from the rights holder to yourself. That is to be understood. You only purchase it for private and domestic use. Where do you play? What is private and domestic use? You play the CD in your car or you play the CD in your house, then it's a private and domestic use. But the moment you play in a public situation, even if no one is listening to that, you have to pay royalty. This is about the principle. There are also people who ask, why pay royalty to a few CMOs for the same music? You must understand in any song, you have different rights holders. So different rights holders will have different CMOs and they will ask royalty. This is important. And another argument which always comes, and this is where the CMOs have to be ready, have to be alert. They say, I play music at weddings which are organized in a hotel. It's a private business. How can it be public? Your wedding is private, but the music is played in public. And what is public? Public is a place where members of the public have access. So that has to be also very well explained to them. And this is another area. But one more area which always comes up at every seminar will be this. And this is another challenge. They say, we are not making money from playing music. Why do we have to pay royalty? But I know of a CMO in Asia which always says, fine. There is no law which forces you to play music. But if you are playing music, you know very well it's not your music. But every music has its work, its rights holders. So if you're using the work of some others, you have to pay royalty. That's a principle. And again, where music is used as a key to business, like in karaoke lounges, then naturally you have to pay royalty. Because business means money here. Music means money. But there are situations where music is used as background music is used. Do you pay royalty? Of course you pay royalty because I'll give you an example of what happened in a Far East country. There were two eating shops where they played music. One eating shop refused to pay royalty. We'll shut down the music, we won't pay royalty. They say fine. Then over a period of 2 weeks and then 1 month, everybody went to the competing eating shop where music was played, they pay the royalty. They realized that eating itself is not music, but background music is important. So they started to pay royalty and play music. Now, what do you see from here? Even if it is background music, it has got a soothing effect of those who are going for entertainment outlets, otherwise for eating shops. This is important. Now, the other frequently asked question, which is to be addressed by CMOs, is why do users have to pay when broadcasting organizations have already paid? Now, broadcasting organizations pay for communication to the public, that's their right. Now you have to pay for public performance when you allow music to come into public situation, which means you have to be very familiar. The CMOs have to be very familiar with all these issues which are bound to come up. So you must be 10 steps ahead of people who tend to ask questions. Now, in a negotiation, there is another challenge. That is, when you go for negotiations with users, it's best you are very much ahead of questions that are bound to be raised. It will be very important for you to tell them the reporting intervals. Do they have to report every week or every day or every month? That will be very, very important. And then, more than that, at a later point, will be the data collection. Now, data collection is fairly hard to get actual usage of works. It's not easy, as we say. The best situation would be broadcasting organizations, which may give you the log sheets. Some countries make it mandatory for the DJs in the radios to record every music that is played or every work that is aired. So that copy can be given to collective management organizations. Fine, that is about the best. Now, what about the performance in other places, hotels, bars, and say dance halls and all that? Now, this is another pressure. This is where the users themselves have to provide data, but this is very intensive and time consuming. They may refuse, but the CMOs have to convince them to provide this data. In some places, CMOs tend to employ inspecting agents, but then the inspecting agents cannot be omnipresent, cannot be present everywhere because of high costs involved. This will be also a difficult situation. Now, this being the case, you have to work out a winnable situation for all. Having collected the data, we are now pressed with the next issue, and that is distribution of the royalty. There must be fair distribution. For fair distribution to take place, the users must be monitored, usage, the works must be identified with the rights holders, and the works must be matched to the owners, and finally distribute to the owners. We have to also make note of certain things which are as follows. You may know Dr. Ulrich Ustangen, who has written Copyright Collective Management Music, which is a WIPO publication. He has made it very clear that there should be only one CMO for one category of rights holders, which I mentioned before. And there is also another statement from him which says, do not set up a foreign agency to monitor local situation. And if there is a monopoly situation in any country, which means only one collective management organization for one category of rights holders, then it has to be supervised. This is important. And CMOs should not be involved in other activities, which is not mandated by members, especially at annual general meetings. I just came from a country where the collective management organizations, one organization tends to throw money for charity works, and when somebody dies, they give a lot of money for the funeral, so much so that the members themselves, members of the collective management organizations, do not get much. So they have to clearly spell out that they should not be involved in other activities. This is another issue. But let me talk about the environment which is proposing both challenge and opportunity. I'm talking about the digital environment, which has imposed very strong pressure on the rights holders and the collective management organizations as well as the users. We know that in a traditional collective management, it is territorially based within national boundaries, fine and clear. But the new media is multi-territorial, a global network. So the management of rights in internet environment needs first updating of legislatures, efficient enforcement mechanisms, and finally identification and protection of the content in digital form. Very easily said, but it is not easily done. Now, you of course have the internet service providers who provide the connections, and they form digital marketplace for everybody. Here, the role of CMO becomes a big challenge because in a digital environment, it becomes a difficult situation for collective management organizations because there is massive use of protected works up in the digital environment, and the users of the copyright works, they need to know from where they can get the licenses for the works that they intend to use. If there is a collective management organization office around the corner here, then that is the best situation. You give a call to them or you visit the office, otherwise you send an email and have communications, and then you enter into negotiations and conclude the deals, straight and simple. But in a digital environment, it is not to be so. Now here is where we have the internet treaties, WCT and WPPT, and later of course the Beijing Treaty, which clarifies the main exclusive rights in the network environment. And the important clause here is making available to the public, which is the internet situation. Now here is where we have the rights management information, which provides details about the owner. And then you also have anti-circumvention measures. But then the member states are required to provide adequate legal protection and remedies for situations where the rights management information is removed. Otherwise, anti-circumvention activities take place, which is hacking. Now, these are very important because once the member states adhere to these treaties, then it trickles down to the collective management organizations which exploit on the national legislation. The last part of my presentation would be one which is being faced daily by all of us. There is increasing pressure on CMOs every day because governments, the electronic and print media, rights holders, users, and the general public are pressurizing CMOs to improve their performance in the areas of transparency, accountability, and governance. The CMOs are pressurized to demonstrate the best practice in conducting their day-to-day activities. They are told to assume full responsibilities in administering the rights assigned to them and bridge a workable gap between the members and the licensees. And importantly, they are told to win the hearts and minds of both the users, members, and the members of the public and those in authority in their respective territories. You may know that at WIPO, there is an initiative called Tag of Excellence Initiative. Now, TAG means is acronym for Transparency, Accountability, and Good Governance. Now, here there is a thought and effort, a move to come out with a purely voluntary application for international quality mark in the form of bronze, silver, and gold. This is being evolved very well, and it is gaining very good momentum, and there is increasing support coming for that. And this is one noble area where WIPO is joining with the international consortium to come out with something that will be of good to the collective management organizations. There are also opportunities which should not be left out. CMOs have a lot of opportunities to build up their strength, build strength upon their strength. And the very first area of their own strength is to look into themselves. The CMOs must be the first organization to train their own staff. As I started off by saying that the leaders must be well competent and well knowledgeable, the CMOs should be able to train their own staff if they have competent leadership. Then, of course, they have international NGOs to also assist. You can see that, for example, for the Author Society, you have a CSAC providing a lot of assistance. They must link up with the parent bodies or international bodies to gain some assistance. Of course, governments do assist to some extent, especially in creating awareness. And insofar as the individual CMO is concerned, you have the very best advertising agency within yourself. That is your website. Website can do wonders. I know of websites where you can see they've placed frequently asked questions, and they address all the salient aspects of issues that are raised by members of the public. The website is about the best form of advertisement. You can print out brochures and supply to all the users, and you of course make use of print and electronic media, and then publish and give interviews on ABC of collective management organizations and conduct seminars. Now, what do we do at WIPO? WIPO also provides a lot of free publications. I shall be happy to share those websites afterwards. And we have nothing less than, say, about 10 publications which talk about various elements of collective management organizations. We have at WIPO put up a video which talks about the basic of a collective management organization. It runs for about 5 minutes, but what is important is all salient aspects of the collective management organization is addressed within the 5 minutes. So there are officers which start the video and stop at a point and discuss for training. This can be also viewed. We are very proud to also mention that you have to make use of the other educational materials on collective management organizations. 6 modules have been put up into WIPO's website, and I have personally received a lot of encouraging reports saying that here at last we have a full range of collective management organization materials. And again, we have videos which are uploaded in the form of YouTubes, and that comes from none other than your own organization, Instituto. And I believe it is creating inroads into many Spanish-speaking countries as well as English-speaking countries, because intellectual property officers, copyright officers, collective management organizations, members of the public, as well as users are viewing and gaining a lot of information and knowledge from them. And to again cap it all, we have a WIPO distance learning program called DL501, which has got very good learning programs on collective management organizations. And I shall be happy to give you the website for that. And once you register and go through that, you become an expert on the basics of collective management organization. Now, maybe, ladies and gentlemen, I think I've covered, as requested by Madam Chairperson, the salient aspects of the issues, challenges, and opportunities. If you ask me if I covered all, I would be honest to say I've not covered all, because covering these issues that have been given to me is like chasing a rainbow. You appear to be going close to the rainbow, but it goes further away from you. This is very wide-ended, but I took it upon myself to address what would be of interest to all of you. And I wish to thank you for listening to me with so much patience, and of course the chairperson for allowing me to speak in the last so many minutes. If there are any questions, I shall be more than happy to answer them to the extent that I'm able to answer. Thank you.